Right, I welcome members to the second meeting in 2014 of the Delegated Powers and Law Reform Committee. As always, ask members to switch off any mobile phones. We have apologies from Richard Baker. Agenda item 1 is a decision on taking business in private. It's proposed that the committee takes agenda item 7 in private. This is consideration of the evidence we are about to take on the draft Agricultural Holdings Scotland Act 2003 Remedial Order 2014. Do members agree to take that item in private, please? We do, thank you. That brings us straight to agenda item 2, which is the draft instrument, not subject to any parliamentary procedure, although you'd hardly know it from the amount that we're giving it. And it gives me the opportunity to welcome from the Scottish Government David BALHARRY, who's the project team leader of this ECHR compliance order, Paul CACKETTE, solicitor, and ASHLEIGH PITCAIRN, solicitor, both from the Scottish Government. So welcome. Thank you for coming. I'm sure this will not be short. Can I also apologise that you seem to be in a far county? It's just the nature of the geography around here. I think we'll go straight to questions on a subject which I think we're all well briefed on, and John Scott will lead that, please.
Thank you, Convener. I'd just like to ask why you have chosen...
Sorry, I should have done my apologies. Go on, Mike. Yes, sorry.
Very happy for John to proceed if he wishes.
Remembering back to where we started.
Thank you, Convener. Good morning. I wonder why you've chosen to resolve the defect identified by the Supreme Court in Section 72 of the Agricultural Holdings Scotland Act 2003 by way of a compliance order and not by any other means such as primary legislation. If your justification is that it enables you to meet the time frame set by the Supreme Court, did you not consider seeking an extension to that time frame?
On the first question of the avenue for resolving the issue, as you know, we were given a year initially by the Supreme Court to resolve the issue of the incompatibility, and we did consider various options as to the way to go forward. One of the options we would have been to have done this by emergency legislation and asked the agreement of the Parliament to put that through in accordance with the procedures that would apply for that. That normally is something that you might look to be doing in fairly quick order when an issue arose. We had the year to resolve issues, and often involves relatively straightforward changes where there's consensus across all sides of the chamber as to what the solution is in detail. And the difficulty here was what we wanted to do, indeed what the Supreme Court encouraged us to do, was engage in an extensive consultation period, having regard to the interests of all the parties, to ensure that we can get to a sensible way forward as well as we could, and deal with that within the timescale concerned. That suggested to us that the process through a convention compliance order that allowed a proposed order to be laid in draft, which is still the stage we're at just now, and then the draft order to be taken into account, would have been the best way to take the time at the early stage of the process and take views on board to ensure that we got a resolution that was ECHR compliant and allowed for an appropriate way forward, balancing the interests of landlords and tenants. The drawback with the order process is that it doesn't allow the Parliament to make amendments to the procedure as we go through. That rarely happens with an emergency bill anyway, because of the timescales of that. But what we thought was best was that by proper consultation in the period we had, which delayed the date at which we laid the order, would allow an order to be put forward that met both sides of the argument and both interests. We were also a little bit concerned to make sure, because of the very sensitive nature of the balance that's involved here, and I know it's been troublesome to some of the witnesses you've heard already, that it is quite difficult sometimes in looking at changes in the course of a bill to make sure we don't do something that had unintended consequences. And we thought that by trying to get through a consultation process at the earlier stage struck the best balance in achieving that outcome. Sorry.
I mean, it strikes me that, you know, from the discussions that we've had in committee about this, that not all the, you know, government doesn't know everything there is to know about this problem even yet, and that not all of the affected stakeholders have perhaps responded to the consultation. Do you not feel that that provides a basis for arguing, whatever the process is, at least arguing for more time, so that we do this properly?
Yes. Well, I was going to ask David if he wants to add anything about the choice of remedies, and then say a bit about the sort of timescales of things, and answer the second question.
Thank you.
In terms of choice, there's nothing to add, but I was going to pick up on the timescale issue, because one.
Just before we go there, I'm just not yet satisfied that these actually fall into the definition, the reasons you've given us, that they are absolutely compelling reasons, which is what we were invited to provide us with a response. And I'm not certain that, I mean, given that we are unable to make amendments in Parliament, Parliament doesn't have the ability to debate this, which would surely have been better, I'm not certain that your arguments are thus far compelling.
That may tie into issues about the question as to the amount of time that we had, and if there were concerns that would arise on the solution that's before this committee and before the Parliament. There is time, and I was going to go on and speak about the options that we have of looking for an extended period. We were very keen, if at all possible, to be in a position where we didn't look to ask the court for an extension, partly because it's their discretion. We'd hope that an extension would be permitted, particularly if concerns were raised by the Parliament, but it's not entirely within our control. But we did feel it was better to use the time to try to get a consensus as far as we could amongst parties. But if we'd asked for a further extension, because of the timings of the extension being April that we have to have the order in place by, the likelihood is that an extension would have taken us a reasonable period beyond April. Then summer recess comes into play, and that would have had the effect of delaying further the point at which certainty could be secured for resolution of the issues, which everybody, I think, is keen to secure. So that we could have asked for an extension, but it was a slightly suboptimal option, I think, to be doing that. It was better, I think, to be in a position that we could ensure that the order hopefully becomes law on 24th April.
Give me amateur law.
Hang on, can we stick with John? I know there are lots of issues because I've got my own. Can I stick with John? Just let John go down his line now.
Make a point of order, if I may.
Yes, of course you can.
I just, before it gets away from us, could you take advice from our clerks as to whether there is anything in standing orders prevents Parliament from debating this? Because it has been suggested we can't.
Can't make amendments, is what I suggested.
I kind of missed
It's specific words that were said, but if that's what you meant, then I'm content.
I think I said we're unable
No,
to make
you
amendments.
said you we couldn't debate it as specific, which is why I was asking. But that's all right. We're clear, John. We're together on this.
Okay,
That's
John,
fine.
on you go. Thank you.
I'm afraid I've lost the train of thought of what I was about to say.
I had a small point I was going to make.
I'll go back to the train of thought that I had, which was that Mr. Cookett said that by extending this into the summer recess period, the ability to provide certainty would be lost. I think you said that anyway. Given that Stuart's official report, he will obviously know. But nonetheless, I am at a loss to know why that certainty could no longer be provided.
Delayed, I think. The concern that would have is that certainty would be delayed. It wouldn't be lost. Because
why would? Well, yes, it would be delayed, but we need. It's fundamental that we get it right this occasion.
I mean, our view is that this is the right approach, both in policy terms and in legal terms, that strikes an appropriate balance. It is a rebalancing of the rights of landlord and tenant, and has been subject to a significant amount of discussion that David has led with representative groups. And we took the view, we knew we had to make a decision shortly before 22nd of November, which was the date we laid the order. That was the last date that we could guarantee in terms of parliamentary procedure that an order, if it was approved, would be through. And we certainly gave some thought at that stage as to whether we felt we had the right answer that sufficiently balanced all the interests, and concluded that this was the right answer to address these issues at that point, and therefore didn't need to apply for an extended period.
And I appreciate that there is some concerns about whether the compelling reason is met, and I wonder in those circumstances if it would be helpful to look at where the Parliament has previously proceeded in this way and what was considered to be a compelling reason. And we have the Sexual Offences Act, the one that I have is 2003 Remedial Order 2011. And in those circumstances, the remedial order was proceeded with. And the reasons given there were that in the absence of any suitable first session bills to rectify the incompatibility and mindful of the need to avoid undue delay, another reason was also speedy action was necessary to avoid further costly litigation and the risk that the domestic courts may decide to award compensation before the remedy was put in place. And I would suggest that those, I think, are reasons which would apply in this case as well. And David will know better than I, but I think that the evidence given, that the weight of the evidence given to the RACI on the 18th of December was that everyone wanted to proceed as quickly as possible. I don't know if those are relevant points or not.
Thank you.
Could I just pursue those points? I'm sorry, I do want us actually to be thorough here. Could I simply observe that any further litigation would itself be assisted by the Land Court, and clearly when you've got Supreme Court judgment saying you can't proceed, no court's going to proceed, so that argument would appear to be at the side. Could I also just ask whether, having been through the process which we have before us, which I'm not trying to disagree with, the government might yet be in a position to bring in emergency legislation, which can, after all, be done really quite quickly, as its name suggests, and that might actually be a practicable outcome at the end of this consultation. Again, I'm not suggesting it's a good idea.
Yeah.
I'm just asking the question whether, in fact, that is a possibility, if that's a way of getting to the right answer at the end.
If there were issues arising from the Parliament's consideration that made it sensible for us to go away and think as to whether this is the right answer, we certainly would have two options, one of which is to ask the court for an extension, and the other, certainly in procedural terms and process terms, although I suspect it's quite messy, but I wouldn't see any reason why, in pure process terms, that can't be done.
Okay, David?
It might just be going over the same ground, but maybe just sort of lay out my understanding as to where the question's coming from. And as I understand it, there's a concern that it's being rushed, and as a result of being rushed, there are some groups of people who may be affected but are as yet unidentified and unknown. And what I'd just like to do is just to go through from a policy side why we are where we are. So ASHLEIGH's made the point that the stakeholders from the outset have said they were given the option as to whether or not we should apply early for an extension. But they said no. There is a key emphasis on getting this right. They want to get it right, and providing we can work and get it right within the time allowed by the Supreme Court, we should try and do that. So where that left us was that we had no real argument to present to the courts for an extension at this time, although we hold it in reserve. But as Paul's made the point, in holding it in reserve, there is no guarantee of getting it. And then I think that's where it then bounces into, well, what would happen if you didn't get it, but you needed more time because of some of the issues that have come up through the committee stages? Then emergency legislation would be an option.
Indeed. Thank you. Stuart? Thank you.
I just wanted to get clarity, which we may not be able to get, on some of the stakeholders' position. My understanding is that some stakeholders do not wish, and have said they do not wish, to disclose their position until Parliament has acted, and that therefore no amount of additional time will enable clarity on those stakeholders' position. In other words, that's unresolvable unless those stakeholders choose to change their position. So therefore, the uncertainty that arises from the decision not to disclose is unresolvable until Parliament acts. Is that the understanding that the government has?
I think that's right. And obviously, people make their own decisions as to how they proceed on their own affairs. But equally obviously, the government wants to make sure this order is right and has sought to do everything it can to inform itself as to the circumstances that it needs to legislate in respect of. And I think it would be unfortunate if there are circumstances out there that this order doesn't cover, and particularly unfortunate if people have decided for tactical reasons perhaps to increase a claim for compensation, not to come forward and tell us about circumstances that we don't know about and can't know about. I think that would definitely be not an ideal situation to be in. And for these people in those circumstances, there is still time to come forward. If this order doesn't cover the scenarios that they are in, and they feel that their rights are being prejudiced in an unfair way, then they should come forward and speak to us. Because we can't try to legislate to resolve these issues unless we know all the circumstances.
And would this not therefore be a benefit of introducing primary legislation, wherein amendments could be introduced at stage 2 and stage 3 in the process, rather than on the basis of once the order is laid, it's take it or leave it, or largely so as I understand it?
Well, that may be the situation. The thing is, we don't know what these circumstances are. We don't know, as Mr Stevenson says, whether even a parliamentary process will smoke out these cases. If people are doing this for tactical reasons, I suspect it won't.
But I think your plea to anyone listening that it would be helpful if they told us that they have an interest is echoed both sides of this table, because at the end of the day, it's very difficult to legislate when you don't know what you're trying to legislate.
It's surely in the general public interest that we know this,
yes,
and can try to legislate to respond to it.
Okay, David?
Can I maybe just add one point, and it's to draw a distinction between the groups of people that are affected by the proposed order and the individuals. In terms of the groups, the stakeholders have all been asked the question, are we content that we've identified the groups? And so far nobody's suggested that we have failed to identify the groups, which in effect, it comes about, the identity of the groups comes about from an analysis of the legislation and understanding the process. So it would be almost extremely unlikely that we failed to identify a group of affected people. There's a secondary question, which is about individuals. And yes, some individuals, to avoid prejudicing their position, we're aware, may not be coming forward. And we've spoken about that. Can I flag up that there are 2 other groups where individuals might not be aware, which we're alert to. One is where they've sold on, so they've through purchase or through selling the farm, they're no longer involved in farming, therefore they're not part of any stakeholder body or in the media, as it were, so they might not be aware. And then there is a possibility that some people have just been busy farming and just practically they're behind with their paperwork, and that's recognised. We think that in those 2 categories, the number of individuals who will be unaware are relatively very small, and we continue to do a lot through membership organisations and through the media to alert them to the possibility of change. I don't know if that helps, but...
Thank you. Stacey?
Have a view of what relatively small means. Are you indicating, in general terms, without commitment, single figures?
So, yes, very much.
Thank you.
Yep. Okay, does that conclude the process questions just at this stage? Bearing in mind that the time when this might come into force is a later issue. Good. Okay, thank you. I think that takes us to question 2 on our list, which this time is to be led by John. Thank you.
Convener, and dealing with section 73, and say that the judgment of the Supreme Court held that the effect of the operation of section 7210 of the 2003 Act contravenes some landlords' ECHR rights to their property, since it prevented them from access to the Section 73 procedure for recovery of vacant possession. Providing access to Section 73 to landlords in groups 1 to 3 appear to be the proposed solution. Could you explain why that solution was chosen and how Section 73 works, and how that is different from the route to vacant possession under the 1991 Act, please?
We've probably covered this as both of us. On the question as to why Section 73 was chosen, ties in, I think, as to why Section 73 existed in the first place. And it was a recognition that in the circumstances that covered the period that was not the bill period, there was a 9-month period that was a difficulty, but it was recognised that even dissolution notices served after 1st July 2003 nevertheless led the possibility that for a tenant to find themselves removed on no notice because of the collapsing of the partnership. So that Section 73 was effectively was the same as the 1991 Act tenancy, but it did not have effectively the succession provisions, and it didn't have the inability to bring it to an end that was the difficulty the court criticised in giving a full 1991 Act tenancy. So it was effectively a kind of halfway house that provided extra protection. What the court implied, and it wasn't directly addressing Section 73, so you can't rely too much on this, but what the court implied was a Section 73 outcome would have been okay in the current circumstances. The difficulty was, for reasons that were not clear to it, the outcome of a 1991 Act tenancy had a disproportionate impact on the landlords. But it was for the situation of addressing out with that 9-month period of the process of the bill back in 2003 that it was felt that that was a sensible solution. That having been the case that struck the right balance between landlords and tenants' rights, and given that the court had criticised the inconsistency of outcomes, the view that we'd reached was that the best way to resolve this issue was to try to ensure that everybody directly affected by the operation of law, by the operation of Section 72, would all be put into the position of being in the same Section 73 scenario. And so, although groups 1, 2 and 3, I think we'll come into this perhaps shortly, although there are different ways in which they get to Section 73, the aim is to make sure that basically everybody ends up in the same Section 73 outcome. Now, for assisted cases, there are different ways to get there. For Group 2 cases, there are different ways to get there. But there are also people who are in Section 73 already, because they have served, and the notice was served after 1st July 2003, and they will already have got into that position. So the basic outcome that we were intending to achieve was to ensure, in as consistent a way as we could, to avoid falling into the same trap as happened, well, that led to the court challenge, that all tenants in these circumstances, all tenants and landlords in these circumstances, would end up with a Section 73 outcome that we thought, with the notice provisions, struck a fair balance between the rights of landlord and tenant. The specific difference, to answer your last question, the specific difference in terms of the rights of tenure are that the lease will have a termination date, because all leases require to, and the lease will end up on that termination date, provided that the landlord gives notice of effectively a minimum of 2 years, I think it is, notice under Section 73, to ensure that the tenant has an opportunity then to make appropriate arrangements to wind down the farm, and make arrangements then to move and move out at the appropriate date. So it's similar, but it gives the landlord what he doesn't have under the 1991 Act tenancy, and that is the ability to regain possession after a due notice period. That period can be shortened if the Land Court permit, but basically it's to give fair notice to allow those arrangements to come to a kind of measured and sensible and coordinated way. But I don't know if Dave wants to add anything to that background.
I don't think so. The only thing I'd, to the Chair, just ask is that I presume that the committee are up to speed with where the limited liability partnership problem, which is at the background to all this, came from. And we don't need to go over that, or would it be helpful just to touch on that quickly?
I think we ought to know. Yes. Yes, I mean, I think the background to this is one we have been well briefed on, let's put it that way. I think we all recognise that we are growing in our understanding of the subject, and hope that by the time we get to end, we may actually understand it. John?
Yes, it has been explained to us. Could I just say, so the Section 73 then is the vehicle of choice, so to speak, and therefore could you just confirm for me that you are content with that, and that it's working well as such?
I can't, from my point of view, the policy side.
We've absolutely no evidence to suggest that Section 73 is not working, and Section 73 as a route to solution was one favoured by stakeholders.
That's fine. I just was seeking really confirmation of that. Thank you.
Okay, thank you very much. That moves us to the next question from Madam, please.
Good morning. Building on your answer to John's question, mindful of the varying circumstances applying to the different groups of cases affected by the judgment of the Supreme Court, how have you sought to ensure that each different group of cases is being treated fair and in an equitable manner?
I think there's two sets of answers to that. One of which is to say that what we've done in considering solutions is sought to rebalance and secure a fair balance between the rights of landlords and tenants in these different circumstances, and the circumstances are different from one another. There are, for example, Group 2, where tenants in good faith may have thought they had a full 1991 Act tenancy for a number of years. They're in a different factual position from the tenants in Group 1, where they knew there was the possibility that they may end up with security, or they thought they might have ended up with security, but they couldn't guarantee that. And what we've sought to do is not, I think as some witnesses have suggested previously, to simply restore the position to what it was in February 2003. We could have done that, but that didn't seem to be fair on tenants in particular. What we've sought to do is to rebalance the rights. So we've required to give landlords further additional rights to respect the fact that in certain circumstances their human rights were breached, as the Supreme Court has held, yet sought through various mechanisms, including Article 3 of the right of what the Land Court can do, and including the cooling off period, to try to ensure that in giving the landlords additional rights, the effect of that on tenants is minimised as far as they possibly can be. So we've tried to do that and applied that kind of reasoning to all the three individual groups concerned. Some cases are in court and some cases are not. Some cases could potentially end up in court. And so we have, as I said earlier on, found ourselves in a position where we really have no choice but to have different avenues to get to hopefully the same solution. It's possible that what we could have done is we could have said for all groups, we'll give it to the Land Court and let them sort this out. Now, we decided that wasn't fair to the Land Court, and we also decided that wouldn't achieve the minimisation of delay and the certainty that we're all trying to secure. But we did recognise that when cases are already in court, we thought it was better that the court then sorts out the cases that are already in court, rather than this order trying to sort out cases. And that's why, effectively, for Group 3, which are the assisted cases, or cases, ongoing cases is probably the better term, for those cases, we decided that Article 3 was the best way to address those, and allow the Land Court then to resolve those, bearing in mind that the Land Court is a public authority for the purposes of the Human Rights Act, and therefore all the decisions of the Land Court have to be compliant with ECHR. So when it makes its decision under Article 3, it'll have to take into account representations made to it to ensure that it strikes the right balance. It's not open to the Land Court to make a decision that contravenes people's human rights. And so we felt that was a sensible solution in that context. In most cases, because Groups 1 and 2 are not in court just now, we didn't think it was sensible to make them go to court to get a resolution, hence the reason, as I say, for the different avenues.
Thank you very much.
Yes, thank you for that. We return to John for question 4, I think.
Thank you. I would like to look at transitional provisions now, and I'd like to specifically look at those in Group 1 who are approaching the dissolution date in the run-up to the order. Can you explain to us what the implications of the order are for them? Please.
Yeah, sure. I mean, Article 4 deals with a particular circumstance, and that is where a notice under Section 72(6) is served on a landlord less than 28 days before the coming into force of the order. The landlord has 28 days to go to the Land Court, but if the notice was served, say, on the 20th of April, and this order becomes law on the 24th of April, then, if it wasn't for that provision, the landlord would lose the right to refer the matter to the Land Court, or rather, he would have only 4 days to do it, whereas we've decided 28 days is a reasonable period. So what Article 4 provides is if this subsection 6 notice is served in the period immediately before this order would become law, then the landlord still gets 28 days to get the matter into the land court to turn it into an ongoing case that Article 3 will deal with. So that's the kind of the most acute timing difficulty if by misfortune any situation arose that the timings are such that it's all around that time. If there are cases that are ongoing right now that should be resolved, then those are cases that could move between the groups. And one possibility is there could be a case that could end up becoming an ongoing case, what may not yet quite be system, but could become an ongoing case and would be covered by Article 3 in those circumstances. Say a notice that was a subsection 6 notice served in November, and then the landlord today makes an application to the land court to say I did this in good faith, I should be allowed my order. Then the court will either decide that before April, or mindful of assisted all the previous cases before, they're more likely to assist the case, in which case it'll become an ongoing case and it'll be dealt with by Article 3.
However, the order does not specify when it will come into force, and I'll come to that in a second. Until it comes into force, there is, as far as I can see, no certainty of outcome for those who have to make decisions about what action to take. And what are you doing to ensure awareness of the implications of the order and understanding of the outcomes of the order, the outcomes the order will provide? And also, finally, if the instrument is approved, have you got a date in mind when it will come into force? Please.
I'm going to ask David to speak about the relations with ensuring that people know what's happening. I think we have indicated, although it doesn't appear in the order because it's a draft order, the intention subject to the parliamentary process is that it will come into force on 23rd April, which is the day before the one-year suspension runs out. And so we don't get into a position that the judgment of the Supreme Court has had effect before the fix is in place.
Thank you. And what are you doing to make people aware?
Yep, so if I can just pick up on that point. The date that we have been working to, although we can't really say publicly because we couldn't commit to it, as Paul says, is the 23rd of April, and the stakeholders that we've been working with are aware of that. I mentioned earlier the attempts that we've made to contact those that are affected. That's those in groups 1, 2 and 3, and they're now on a mailing list, and they're regularly updated in terms of progress that's being made in each stage that we're at. So insofar as the clarity that we have helps them inform them of the choices they have, they're in exactly the same position as we are.
I see somewhere, perhaps the Scottish Farmers, I mean, a helpline set up by one group or another.
There is two. SDFA have set up their own helpline to give legal advice to people affected. That may flush out some that we're not aware of. We also have, we Scottish Government have our own website where people have registered and gone through a questionnaire to help us identify what group they're in. And then through knowing what group they're in, we're then giving them relevant information.
And you doubtless further encourage people to respond to one or other of these helplines.
I think we just add one more point. We may come on later on to talk about the cooling off period and what's done about that. But one of the other points we made in the specific context is that because people will only know with certainty, hopefully, on 23rd April 2014, what the final version of this order is, the idea of the cooling off period or giving time then to take advice and think about what to do at the point that they can only then say with certainty what the law actually is an argument in favour of the cooling off period, so people can have time to take professional advice and then decide what to do, rather than feeling they have to dash into a decision-making process immediately after that date.
Okay. Brings us to question 6, and Margaret. Thank you.
The ongoing cases, can you explain the effect of Article 3 of the order as read with Section 72A1, please?
Yes, as I said earlier on, the purpose of this is for cases in one form or other that are in the land court. It's thought appropriate that the land court should be the appropriate place to resolve those disputes. And although I think one of the witnesses earlier on had indicated that they thought the government's preference was cases would be taken out of court rather than go through Article 3, I have to say that was not what we had in mind. What we had in mind is cases would be dealt with by the court, and the parties would ask the court to resolve the issues before them in an appropriate way, and in particular in finalising, once clarity is secured, reading the judgment with the final order, the court would then potentially make, we think, probably two decisions, one of which relates to the question of the termination date in terms of the order. Now, for assisted cases, I think probably, I suspect for all cases, certainly the vast majority of cases, the termination date will now be at some point in the past, because these cases have been assisted for some time. I think are almost certainly proceeding by tacit relocation. Then to give the court the ability then to decide what, when it goes forward, the appropriate termination date would be, seemed to be us a sensible way forward, and it can then balance the rights of the landlord, who, if they were entitled to repossession, would then get that repossession at a date that was able to reflect and allow the court to take into account what the tenant was saying as to when that date should be, and hopefully achieve the right balance in those circumstances. So it's to enable the court to make a determination. The court wouldn't have the power itself to change the termination date unless it was given to it, which is why Article 3(3)(b) is in place. We were also mindful, in order to make sure people don't have to go to the land court twice, that if a landlord wished to secure a shorter notice period, again, given that the case is in court already and everybody knows what the position is, Section 73 allows an application to the land court for a shorter period of notice. What this allows the land court to do is deal with all in the same ongoing action, rather than making the landlord finish one case and then go back to the land court for a second case, which didn't seem to be us to be desirable.
Could I just pick up on what I think I heard you say there, which was that the Land Court could effectively change the date of the termination if that was appropriate. What I thought you might have said was if termination was appropriate, whereas my understanding is that any case that's got to the Land Court, the landlord is automatically, termination of the lease is not in dispute. It's only a matter of the timing.
Yes, yes. And it is the term that we set out in the lease. So the lease will already have a termination date, whatever that might be, and the normal expectation is it would end at that date.
Yep. Yes, that's okay. So there is no circumstance under which the court, by this route, will be allowing a lease to run on beyond a fixed termination date.
Not unless it requires to do so to respect the human rights of the parties concerned. Now,
do you elaborate on that? Because that's a very interesting thought.
Yeah, that could, for example, arise if, for example, there was a situation that by misfortune of timings, the termination date is, say, August 2014. And if you have that situation, the Land Court might decide, when this order becomes law, as we hope it will do on 23rd April, that actually allowing the term date per the lease, if it was August 2014, would be too short notice to be fair to the tenant to have to get out on such short notice, and might actually decide that a longer period, given that Section 73 requires 2 years' notice anyway, might decide that a longer period is appropriate in the circumstances. If the termination date is more than 2 years hence, I'd be pretty surprised, I mean, if the Land Court makes its own decision, I'd be pretty surprised if the Land Court would give a longer termination date in those circumstances. Obviously, the test before it is reasonable, but that's an example where it might be argued that the tenant's Article 8 rights of occupation, and of course many of these farms are occupied as family homes, as we all know, as well as working farms. There can be circumstances, you can imagine, where it wouldn't be fair to allow a very, very short termination date to be given effect to. But those, I think, are quite rare circumstances, but this gives the flexibility to allow that.
And if I can just come back to the point, everything you've mentioned gives a termination date rather than a termination event. So am I right in thinking that there is no prospect that a court would say that someone has possession for life?
I would have said that's not an option that's open to the court in light of the Salveson and Riddle judgment. And certainly a situation where they're effectively setting an uncertain date and excluding succession rights. I mean, it would be up to the court again, I'd be surprised if it would would consider the right balance of rights between landlord and tenants would lead to that conclusion.
Can I concur with your scepticism? But my question is not to ask you, in fairness, to second guess what the court might say, but what the legislation and the order before us would allow. Am I right in thinking that what we've got before us would at least allow the court to come to that conclusion?
It would, in theory, allow the court to come to that conclusion. What the court would have to take into account is what Salveson and Riddle, the Salveson and Riddle judgment in the Supreme Court say. And that was not that what happened in 2003 couldn't have been done, but there was a disproportionate impact that breached the human rights of landlords in certain circumstances. And if that outcome of giving an extended period, for example, for life, would also go too far, effectively, in protecting the landlord's rights, then it wouldn't be open to the court to do so. So it's one of these cases that it's theoretically open, but only it would only be open if the landlord's rights were breached, which the Land Court is not capable of doing, for the reason I said earlier on.
Forgive me, you've now lost me. Does that mean you think that it is open to the court to allow a lease for life, or in fact that's inconsistent with the Supreme Court judgment?
It's potentially inconsistent with the Supreme Court judgment. What we don't know is whether that outcome would be regarded as disproportionate. Because what the Supreme Court told us is the outcome cannot be disproportionate in terms of the implications for the landlord.
David, do you want to add on that? Sorry, the colleagues want to come in.
Yes.
It might be extremely unwise, but I'm not a lawyer, so I could maybe give a policy answer to the question.
Yeah, I think a policy answer is acceptable, given that my question is clearly somewhere in between. So right. Go on.
Policy answer would be that my understanding of the Supreme Court judgment is that to be in a limited liability partnership as a tenant and to end up with a fully secure 91 tenancy is an unlawful and disproportionate outcome under ECHR. Therefore, in terms of as it moves forward, the court acting reasonably, your question implies that they would then have to go against that ruling, which would be to overcome something that they've identified as being unlawful and disproportionate, given where it came from. And I would say it's just not possible. But I'm not a lawyer.
Indeed. Thank you for the discussion. Do colleagues want to comment on that in particular, John?
And I'd hastily add, not am I a lawyer, but you mentioned almost en passant implications of tacit relocation. Can you just talk about that a little bit more? Because explain the term again to me, yes. But also the implications of it yes. in the context of how you used it.
Apologies, jargon tends to be a fault of lawyers generally, and when you're immersed in this kind of stuff for too long, you use it too regularly. The concept of tacit relocation is that in any lease, agriculture or otherwise, it has at least will have a term date or a period of duration. But it would come to an end if notice is given by the landlord to the tenant that the lease will come to an end. If the landlord doesn't give notice, and often can be happy that the tenant stays in occupation, then by tacit relocation, by not giving the notice, the lease in these circumstances would continue on a year-to-year basis. So that if no notice was given before the end of a lease, it would simply carry on a year-to-year basis, and then the landlord could give notice ahead of the next year, but would have to comply with the notice provision, so they would be able to get repossession, but at least would continue on a year-to-year basis after that on the same terms and conditions.
And it wouldn't ultimately lead to a secure tenancy?
No. That in itself doesn't lead to secure tenancy. Obviously, the 1981 Act gives special provisions that allow that to happen, but that in itself doesn't give rise to secure tenancy.
Okay, thank you.
I just wanted to be clear. I've heard several times that the Land Court, or indeed Land Tribunal, cannot, in law, act illegally. I just wonder if it was possible for you, to a layman, to explain how that can be so.
Section 6 of the Human Rights Act, 1998, and if I talk slowly enough, I've got it here.
Do forgive me. Let me explain my likely misunderstanding. It's not that I'm questioning whether there's a legal provision that prevents them from acting illegally. That I understand. But what was being said was that in law they couldn't. In practice, in other words, if they sought to do something which actually was in contravention of the provisions that govern their operation, how does that get sorted out, is kind of what I'm asking.
The technical answer is Section 6 of the Human Rights Act. It is unlawful for a public authority to act in a way which is incompatible with the Convention right, and that section defines public authority as including a court or tribunal. So that's the technical answer. If, in a particular case, they made a finding that contravened that, I think the simple answer in our view is it would be appealable. As indeed happened in the Salvers and Riddle case, the decision of the Land Court ended up being appealed to the Court of Session and ended up being up in the
I think that's sufficient, and that's what I expected. I just wanted to hear it said.
Okay, thank you.
Okay, have we moved on then? I think we've got to question 7 and Mr McMillan. Thank you.
Thank you, Convener. There appear to be different views about the scope of the powers given to the Land Court and the direction to the Court to dispose of the application before it, as it considers reasonable. Can you explain what the Court is being asked to do and what discretion it has, and how may the powers in Article 3, subsection 3 be used?
I think the first thing to say about the ongoing cases before the Court is we would expect this to be recalled after the order becomes law, and then the courts will have an application under 72(9) before it, which gives it, on the face of it, an option that's no longer open, and that is the option of giving a full 1991 Act tenancy, because that's now excluded as an option by virtue of the decision in Salvers and Riddle. The effect of the order is to say that the order giving immediate vacant possession is no longer available because that will have been repealed when the order comes into force. And so it's in that context of the order effectively transferring the right of the tenant into a Section 73 right, then the Court will make an order, in effect, just confirming the existence of a Section 73 tenancy. And what the order will then set out is, if it's minded to do so, the issues as to whether any period of notice should be shorter or what the termination date should be. But if it doesn't do any of those things, it would simply close off the case, giving effect to the options open to it now because of the order, which excludes the ability to do anything other than go through Section 73.
Some stakeholders question whether the Court could uphold the Section 72(6) tenancy, and that this would conflict with the Supreme Court decision. Does the order give the Court the power to actually do this?
Can't do that. The Court does not have the power simply now to give a 1991 Act tenancy. That's an option that's excluded by the Salvers and Riddle judgment.
Okay. And there also seems to be a difference of view as to what will happen to Group 3 cases when they reawaken in the Land Court. In particular, can landlords abandon the action unilaterally, or must the Court determine what is to happen to the tenancy?
As in any other litigation, the parties can abandon if they think fit. And that would normally be done by an agreement that it doesn't want the Land Court to determine the matter. So there's no necessity for the Land Court to make any kind of substantive judgment, and there never is. A Land Court will always want to have an order of the Court that disposes of the case, and if the parties simply agree between themselves as to what the outcome should be, then there still will require to be an order of the Court. But it's not necessarily the case that the Court will have to apply its mind to the merits. It needs in procedural terms to get out the Court, because cases shouldn't sit in the court forever. But if the parties come to an agreement between themselves for the resolution of the dispute that's with it, the court would have to give its blessing effectively on the outcome, and it would do so by a court order. But there'd be no necessity for the court to apply its mind to issues if the parties don't want it to.
Okay, thank you.
Takes us through to Stuart. I'm sorry, John. Apologies.
Could I just say, if I may, that Scottish Land and Estates have raised the suggestion that the order is possibly not compliant with ECHR as it gives landlords adversely affected by Section 7210 a disadvantage of an additional year before gaining vacant possession when compared with other landlords whose limited partnership leases are only subject to the Section 73 double notice procedure. Could you just deal with that assertion from that body, please?
Again, I'd refer to what I said earlier, that what we're not trying to do is simply restore the February 2003 position. What we're trying to do is strike a different and better balance between the rights of landlords and tenants. And there's no doubt that there are bits of this order that are going to make a landlord wait longer than they would have done had none of this been legislated on. But it's legitimate within the options of the government to do that, so long as it's reasonable to do that, and so long as there is a counterbalancing reason to explain why that is regarded as being necessary. And one of the things that comes into play in that context is the issue about immediate vacant possession. If it is literally taken to be the case that the collapsing of a partnership through a dissolution notice would allow a landlord to secure instant vacant possession at midnight tonight, then we certainly consider that would contravene the tenants, or potentially contravene the tenants' Article 8 rights to get some kind of notice. So actually, by making the landlords wait longer, which undoubtedly bits of this order do, that's balanced against the fact that we're looking at landlords and tenants' rights, and that by putting provisions in place through the cooling off period and some of the examples that you give there, that's designed to ensure that a fair balance is secured, so that landlords will get their vacant possession at the end of the day. They'll have to wait a little bit longer for it, but the necessity to do so is to take into account the human rights of the tenants.
Notwithstanding other areas as well in this order where you would acknowledge that there may be an argument about whether or not it will now be ECHR compliant, or is that the only one? I mean, I can see there is an argument there, and I accept your justification to the point you're making the grounds of reasonableness. Yeah. But are there other areas similarly like that?
Yeah. Yes, I mean, we're not aware of circumstances that are likely to arise or possibly might arise where those kind of pinch points arise. David's reminding me that one of the issues that has been put before, and it relates to Group 2, as to whether we ought to have effectively an opt-out of the conversion process rather than the opt-into the conversion process. And that's an example there where actually it's possible to envisage circumstances where, from a landlord's point of view, they might potentially get a windfall from being in Group 2 circumstances. And what I mean by that is, say there was an agreement between a tenant and a landlord way back in 2003, and the reason why the full 1991 Act tenancy exists is because the tenant paid the landlord a sum of money not to go to the land court, and has got into a situation where the tenancy exists as at present. By giving the conversion, by making a conversion over, there's a potential risk that a landlord might gain a windfall in those circumstances. Having received money to not go to court, what this order has the potential of doing is leaving the landlord in a position where they could basically renege on that deal and then convert the lease into a Section 73 lease. Now, what our view is in those circumstances is that the reason why we give the landlord, we make the landlord make that choice, is if the landlord were to do so. And our view is he'd have to think very carefully before he did so in those circumstances, because that will leave himself open potentially to a claim by a tenant of unjust enrichment because he has gone back on his deal. That's actually the reason why we have an opt-in rather than opt-out. So the order is ECHR compliant as it is, because it requires the landlord act their own hand, not an onerous thing to do, as I think was suggested, but simply serve a notice. But if they do serve a notice, they have to think carefully. Landlords will have to think carefully before they serve a notice, because if they actually did genuinely acquiesce, maybe for exchange of money, maybe in other circumstances, if they genuinely acquiesce and they still convert over, then they do leave themselves potentially vulnerable to a tenant saying through other court process, as I say, somebody making a claim for unjust enrichment or an enhanced claim for legal compensation at the end of the lease, they could leave themselves into a position where the Landlords Act has given rise to a claim for compensation by the tenant from the landlord. So that's an example of a situation where this is designed in such a way to make sure the order is ECHR compliant, but the way that a landlord operates it, if they do make the positive step, take that positive step to convert over, they could leave themselves vulnerable to a claim.
Could I?
Many thanks.
Let's pursue that, because it was,
Yes,
it was an issue I had actually wanted to come to, and now that you've got to
Yes.
it, let's pursue it, please. As you say, the landlord may have received money for the 91 agreement. He may not,
Indeed.
but there may be very good evidence in legal terms that he intended to give the tenant a 91 agreement,
indeed.
but he didn't do so under duress, and both parties admittedly misunderstood the law, because everybody misunderstood the law, but nonetheless there was a very clear evidence that he wanted to give a 91 Act tenancy, not just, of course, to the tenant, but to the tenant and his successors.
Yeah.
And that is not irrelevant in the context of farming law, as everyone, I think, now appreciates. Is there not a reasonable possibility that some of those farmers might actually have a higher claim to the 91 tenancy which they thought they got than the landlord has to his land back?
Yeah.
In ECHR terms. But if that's the case, and if your first answer is yes, because I think it has to be, at least in principle, then why does the order not allow in that case that the tenant can go to the land court with the opportunity of getting his 91 Act tenancy confirmed, because that is the correct ECHR-based solution, rather than the presumption, which we still have, which is that the landlord can, regardless of what he may have said for value or otherwise, get his land back and is merely open to a claim. Is that really what we should be doing?
Yeah. Well, one of the difficulties is that option of looking to treat landlords in that kind of way was actually is quite a difficult option to pursue in terms of the way that the Supreme Court issued its judgment, because it really effectively said that there were some categories of landlords who could not have proved a case by going to court that they were in effect good faith, as was defined in 2003. So it was quite difficult to do anything other than give the right of conversion over. And as I say, the way the order is designed is intended to provide at least for an appropriate remedy to the tenant in the circumstances. Could it have been possible to have effectively reinstated a kind of land court process to allow the tenant to have done so? Again, in theory, that's possible, but I think our concern was that the process of going to the land court to try to prove factual circumstances of good faith and bad faith was really one of the difficulties, the problems that got us into this difficulty in the first place. And it was felt that that wasn't really a sensible way forward in those circumstances to allow someone to resolve their issues that way. What they could, as I say, do is look for legal compensation, and insofar as that was inadequate, they could look to make a claim for unjust enrichment.
But the evidence they would have to lead in that case for unjust enrichment is surely precisely the same evidence as they would have to lead in the land court to retain the 91 tenancy were that an opportunity.
Yes, but it would allow them to get, if you like, the financial compensation that would arise either way through that process. And so what they'd effectively, in terms of their financial loss, they'd be able to be put into that position through a kind of an existing process of law, rather than creating an additional process of law. So it might not make much difference at the end of the day, but our sense was it was better to rely on existing processes and existing law to resolve these sorts of issues, rather than creating new land court processes that have been so unpopular in the past.
I can understand that, and with the greatest respect, I think everybody would see it that way except the farmer.
Yeah. Yeah.
Because the farmer is not actually looking for compensation.
Yeah.
He's looking for the farm, which he has put his significant part of his life in, maybe over the last 10 years. And compensation is actually not what this is about. He actually wants to be able to farm that land. He has got perfectly decent legal evidence that it was intended he should have a 91 agreement. Mm-hmm. And we're taking it away. Yeah. When we're quite prepared to acknowledge that there may at least be an arguable case. The balance of the arguments in ECHR terms, which is what the Supreme Court judgment is about, would be in favour of him retaining that 91 agreement. That's the challenge, and I think that is a real challenge to us, because I must confess, this is the one point on this order where I'm still worried. I'm genuinely not sure that in this case we've got the right answer. I don't know whether there's any more to say, but I think that's a real concern. I'll bring it to you in half a moment. Let's just see if we can get an answer. Sorry.
The only thing I was going to ask for is just to reiterate what you see as the concerns, to make sure I understand it. And that's that there's a situation out there where the farmer is in receipt of a full 91 tenancy that was given in good faith, not as a consequence of anything to do with the defect, but it was just given in good faith as the end of the serving of the claim notice.
I'm hypothesising, but I am aware of farmers who are at least close to this, and I'm not going to evaluate the evidence, but where there is at least the potential of a 91 tenancy in good faith superseding the limited partnership, where there is quite possibly sufficient evidence to demonstrate that that was the intention of the parties, the law having changed or not having changed.
Yeah. No, I can see your point. I think that's something that we need to take away and reflect on.
I think if you could, that would be helpful, because that looks like a lacuna in this. Stuart, sorry.
Well, I was just going to go to the judgment in this regard, and section 56, where Lord Hope is quoting the Marks v Belgium, etc., and various other cases. But essentially, at the end, he says, this suggests that closed cases of whatever kind should be allowed to stand. And then makes the qualification that where the legal application of 7210B has drawn, has been what has caused the outcome, that can be reopened because it's under Convention Acts. Now, as I read it and understand that, and then looking at the conclusion which draws from that, that would mean that only where the application of the law has been directly used is it open for this agreement, which was made privately between parties, to be reopened. In other words, that closed cases of whatever kind should be allowed to stand is what he appears to be saying. Now, I say this as a lay person reading, a judgment that's not without complexity. Is that a fair way for me to read it?
I think it is, yes, absolutely.
So it's quite clear that Lord Hope is saying if a commercial arrangement were made, even though the hidden hand in promoting the outcome through that commercial negotiation was a law which is now being struck down, it is unaffected by the judgment that he is making that 7210B is ultra vires.
Yes. And in fact, that actually kind of encapsulates, in one sense, why the order deals with groups 1, 2 and 3 and not group 5, which is the bilateral agreement, where what we've tried to do is provide a legislative solution for where the operation of law leads to a difficulty with ECHR. while some of these other agreements undoubtedly would have been entered into in the shadow of Section 72 and influenced by it, nevertheless they weren't required to be entered into and weren't a necessary consequence of that, and that's why that distinction is drawn. So I would agree with that proposition.
Well, if I could ask you to reflect on whether there's a subgroup in 2 which is nearer to 4 or 5. Yeah, I think that would be helpful, please. I suspect you probably already said enough on the fact that tenants in Group 2 will be subject to even greater, ignoring the previous discussion, will be subject to greater uncertainty, or uncertainty for a longer period of time because of the cooling off period.
Yes.
And I imagine the reality is that they're in the same place as their landlords have to be in order to allow them at least the opportunity of sorting themselves out before they have to go to court. Or,
Yes.
Yeah, I don't think there's anything else to say there. Right, in which case I think we've now got to question 10, which I'm hoping... Sorry, but John, please.
If I may, possibly straying into policy here, but does this order have implications for the ministerially-led review of the Agricultural Holding Act? In as much as there's a renewed emphasis on being ECHR compliant, and in the 1991 tenancy and the ability to terminate that tenancy reasonably. Does an absolute right to buy, therefore, would that be less likely now to be ECHR compliant than it had been interpreted to be hitherto?
I'll ask David to say something about the kind of wider policy implications for the review. I'm not sure that the judgment has particular implications on questions of absolute right to buy because of the difficulty that arose in the peculiar circumstance of Section 72 as it was enacted. The provision was an anti-avoidance provision because of the unusual circumstances that were in play, and the court said that anti-avoidance measures of that nature are not illegal as such. What it said was that a disproportionate outcome on a landlord and an inconsistency with pre-July 2003 and post-July 2003 circumstances led to the need to set aside the implications of subsection 10. I'm not sure I see there's a read across absolute right to buy as such, but David may want to add something about the general policy context. Yeah.
Unless it actually relates to the order before us, because I'm not convinced this is, but feel free to answer the question.
I was just going to make that point. There are sort of two issues in the absolute right to buy. One I can answer and one I can't. There's the one I can't answer, which is about the ECHR compliance of an absolute right to buy in terms of agricultural holdings review. That needs to overcome or to provide what is the overriding public interest. That's beyond the scope of anything to do with our order, so I'll leave that if I may. The other bit, though, that some of the stakeholders have commented on as a genuine concern is that the opportunity provided through the cooling off period for mediation could be, in an extent, compromised because of a fear that the longer that the landlord stays in that position, the more time that they are exposed potentially to an absolute right to buy. So, in effect, even although there's a mediation period there, the wise money from the landlord's perspective would be simply to regain vacant possession as quickly as they can to avoid this threat. In looking at it, though, where the confusion comes from is that if you were in a limited liability partnership, there is no doubt that you had a 91 tenancy. The difference is, though, that 91 tenancy is not heritable, as a normal 91 tenancy is. And all the public statements that the Cabinet Secretary has made with regard to looking at absolute right to buy, he's made it very clear that that is only being considered in the context of secure 91 tenancies, i.e. those that are heritable. And with that definition, none of the tenancies that we're speaking about in here are within the scope of what's been announced in terms of a review of absolute right to buy. And that should be reassurance to those involved.
Does that take us to question 10? Please. I think it takes us to question 10.
I just want to look a little bit more, because most of our discussion has been about the negative impact on landlords, about potential negative impact on tenants that relates to this. Lord Hope uses the phrase the process that we are undertaking should be conducted in as fair and constructive a manner as possible. I note, however, that of course he has not yet struck down 7210B. He has indicated that it's incompatible, but not yet struck it down. So, do you think that this is a process that can be defended as fair and constructive in relation to the removal of expectations from tenants who, under 7210B, had made plans and were reasonable? And how would you seek to say that it was fair and constructive?
Certainly, if for groups 1 and 3, then those are processes that were always going to be subject to a court determination and court resolution. So the position for tenants was never going to be one of any certainty that they could get outcomes until the end of that bit of the process. The circumstances of a tenant in Group 2, I think, as recognised, is different, because they could well be in circumstances where, in good faith, they have thought that they were in a position that they enjoyed the benefit of a full 1995 tenancy, and the difficulty, particularly in those circumstances, is allowing that to continue, subject to the discussion earlier on about a court resolving factual circumstances. That is unfortunately an inevitable outcome of the decision of the court, and we've tried to reflect that and tried to respond to that in terms of the order. It is a very difficult balance to strike in trying to do something that accommodates what the court requires us to do with reconciling the two rights, but I certainly recognise the difficulty.
Could you just remind us roughly how many Group 2 tenants we think there may be?
5.
5. Right. And potentially 5 entirely different circumstances.
Yes.
And ultimately, the tenants, if they have been disadvantaged by this, have common law recourse.
Yeah, they have remedies, and that's one of the things we're conscious of a number of aspects of this when deciding what we felt was the best way forward. But one of them is not to forget the fact that there are other common law and statutory remedies that can resolve some of these issues at least, and they don't all necessarily have to be covered by the order.
Sorry, I'm just thinking ahead. Of these 5 tenants, roughly how many acres are we talking about? You may not know, of course.
It's something that we could probably write to you and get the figure for, but I wouldn't want to just say off the top of my head.
No, that's fine. It's really for interest. I don't think it actually influences the process, but it gives you a sense of, how much we're closing in on the last fragment of difficulty.
On the type of farm.
Yes, of course.
Okay. I think the last question, which I'd like to address, is simply about how you feel you're communicating with those who are currently interested. I think we've heard lots about that, actually. How you're communicating with those who are identified one way or another through the process, and I suspect some of them will quite literally be listening in now and trying to understand what we're doing, but how are you communicating to those who will be out there doing other things in the fields rather than listening in to this? And also, what do you see as the ultimate communication process on this? I mean, this is, well, I know sort of statutes and instruments are published in the normal way, but there would seem to be scope here for doing things slightly beyond the normal way. I'm just interested to know how you think this is going to be communicated when the time comes, because time is of the essence.
I mean, I don't think I've got any magic solution, but I'm open to ideas. So we're using the standard ones, which is that we have our website, we have people registered, we'll be writing to those that we're aware of directly and giving them information. The stakeholders, through their committees, membership lists and so on, are letting the members know, and in news articles. Beyond that, I'm unaware of any other sort of magic solution.
I wasn't expecting you to have one. We've been looking for magic solutions for a long time. Yeah. Could I ask then, once the order is published, does that come with a set of guidance as to kind of what it means? Or do individual folk have to go and get their own, probably very expensive legal advice as to what it might mean?
Yeah. So what Paul's saying, just reminding me there, is that when we will issue a policy note, and we can be mindful in the drafting of that policy note to, in plain English, make it the options that are open to people as clear as possible. What we couldn't do, obviously, is to make suggestions as to which option they should be taken.
Thank you. Steve?
Just given that we seem to have established that there are 5 people involved here, is the government prepared to allow its officials to sit down with each of these 5 people and talk through the implications of whatever solution is ultimately come up with? Because rather than trying to second guess what their interests are, if it's that number of interested parties, would that be an appropriate way forward? And is the government prepared to do that? Or at least take the idea away and think about it?
So at the moment what is proposed is that during the cooling off period, the government will pay for independently accredited mediators to mediate. Now, mediation requires voluntary engagement, and if the tenant and the landlord side are willing to have Scottish Government round the table, then yes, I'm fairly sure that will be something that we'd look at.
I think John was...
I do. I want to apologise to everyone and the committee particularly. I should have declared an interest as a farmer before this point in these proceedings. I now wish to set the record straight and at least declare my interest as a farmer and a landowner.
Convener, just by the same token, I do have a 3-acre registered agricultural holding from which I derive no income whatsoever, nor do I receive any money from the government. But just for the sake of completeness, I'll join Mr. Scott in so doing.
Indeed, thank you very much. These things are always a sensible precaution. I'm wondering if I could just go slightly off-piste and ask one other question now, and I'll do it slowly, of course. And that is just that discussions elsewhere, the idea of the time bar and the time within which any litigation might have to be brought has been raised. People, I think, suggested it had to be 5 years, and then it was reduced to 3 years, and then I think it was myself who suggested it might be 1 year, and there's always at least a theoretical possibility that might be 1 year from the point at which the Supreme Court ruled, which, of course, would be really undesirable. First question, please, is the government minded to put anything on the order about timing? Because we haven't seen it yet, of course. And secondly, do you have any views you can express about time bar in the context?
We don't think it's appropriate to make specific provision in this order for time bar. The circumstances will be many and varied, and I'm not sure I could really say as to what the period would be in any particular circumstances. But when I mentioned earlier the fact that a lot of the remedies here are those that exist at common law or in other statutes, there is a provision in the Prescription Limitation Act, I think it's section 19A, that allows a court to effectively allow cases to be raised out with a time bar period where it's equitable to do so. And where a case can be made to suggest that the equities require that to be allowed, then the court would allow that in the circumstances. And our feeling is that's the most appropriate way to deal with any suggestions of the very sort of unfairness you refer to would arise, and that the court's best placed to do that, assessing the facts and circumstances of the applicant in that case.
Does that not, however, put an onus on a potential litigant to decide whether or not they want to put themselves at the mercy of the court, or whether they should actually raise an action in a hurry in order to make sure that they don't have to worry about the court's discretion?
Yes, and that does happen in litigation where close to time bar periods, litigation is raised from time to time to protect the position of parties, and then it gets sister again, pending resolution of that.
In the context of this particular order, and if there is any genuine uncertainty, would it not be appropriate, possibly kind would be a useful word, to actually put something in the order that ensures that litigation can be started rather later and just take that pressure off people who probably feel they're under enough pressure anyway?
It's certainly, obviously, it's an issue we could take back and consider. Our sense is, as I say, that the provisions in legislation just now are sufficient, but we can certainly review that and give some thought to that in the circumstances as to whether it might be appropriate.
Okay, thank you very much. Right, I think that brings us to the end of this item, unless anybody else... Right, I think that does bring us to the end of the item. Thank you very much indeed. I shall briefly suspend the meeting just to allow you to go and possibly to have a cup of tea or whatever. acceptable? Guys, we got 3 to 6 and then we get the private bit afterwards. Okay, right. Thank you very much. Okay, resuming with agenda item 3. No points have been raised by our legal advisers on the Proceeds of Crime Act 2002, Disclosure of Information to and by Lord Advocate and Scottish Ministers, Amendment Order 2014 draft. Is the committee content with that instrument, please? Thank you. Agenda item 4 is instrument subject to negative procedure. No points have been raised by our legal advisers on the National Health Service variation of areas of health boards, Scotland Order 2013, SSI 2013-347, nor on the Colleges of Further Education Transfer and Closure, Scotland Order 2013, SSI 2013-354, nor on the Plant Health Scotland Amendment Number 3 Order 2013, SSI 2013-366, nor on the Scotland Act 1998 Agency Arrangement Specification Order 2013, SI 2013-3157. With regard to the first of these instruments, SSI 2013-347, the committee may wish to note the Scottish Government has agreed to correct a typographical error contained in this instrument by correction slip. Does the committee agree to do so? We do. And is the committee otherwise content with these instruments? Thank you very much. Agenda item 5 is instruments not subject to any parliamentary procedure, and no points have been raised by our legal advisers on the BVD Scotland Amendment Number 3, Order 2013, SSI 2013-363. Is the committee content with that instrument, please? Thank you. Agenda item number 6 is Public Bodies Act Consent Memorandum. This item of business, consideration of the public bodies, abolition of the National Consumer Council and transfer of the Office of Fair Trading's functions in relation to estate agents, etc. Order 2014 draft, the United Kingdom Government Order under Section 1 of the UK Public Bodies Act 2011. The consent of the Scottish Parliament is required to make an order under Part 1 of the Public Bodies Act 2011, where such an order makes provision which will be within the legislative competence of the Scottish Parliament. The Delegated Powers and Law Reform Committee considers and reports on each of such orders under the same grounds as instruments laid before the Parliament. Paragraph 1 of Part 1 of Schedule 1 of the order provides for the omission of the entry relating to the National Consumer Council in Part 2 of Schedule 1 to the Public Bodies Act 1958, when it should omit the entry in the Public Records Act of 1958. However, the committee may wish to note the explanation provided by the Scottish Government. The Department of Business, Innovation and Skills has advised that the statutory instrument registrar will issue a printing correction slip to correct this patent error. Does the committee agree to draw the attention of the Parliament to this order on the general reporting ground as it contains a minor drafting error? Does the committee also agree to note, however, that steps are being taken to correct that error? Okay. With that, I can then move the meeting back into private again. Thank you.